Hi, good afternoon, everyone. People are still trickling in, but I'm going to go ahead and get us started. Thank you so much for joining us for the first webinar in our Special Asset Summer School series. This class is led by Jameson, Doub and Thomas Wolff, and we're going to delve into strategy. Well, I say they are going to delve into strategies for surviving and thriving in Subchapter V Bankruptcy. I'm Haley Cook, Marketing Coordinator of Events and Proposals here at Ward & Smith, and I'll be your moderator this afternoon. Just a couple housekeeping things. If you have any questions or issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try and troubleshoot with you. Just take note of a couple things along the Zoom bar. Your Q&A, and we are happy to take questions during this webinar. If you have a question, please type it into the Q&A feature and we will address it at the end or at the conclusion of the webinar. We don't have any polls today, but right here you'll see a chat feature. There should be a chat feature where you can click to message me directly. I am showing as Haley Cook. You can message me directly or just message hosts and panelists, and that'll come to all three of us. And then of course you could raise your hand, but I think the best way to get our attention would be to chat us or do the Q&A. All right. So before we get started, I just want to remind everybody that this webinar is being recorded, and it will be on our website and our webpage probably by the end of the week. Just as a friendly reminder, I know that we have some familiar faces with us. We do post all of our webinars on our website under past webinars, and so you can access those at any time. But I'm going to go ahead and introduce our speakers today. First is Jameson Doub. This is his first Special Asset Summer School series. So welcome, Jameson. I always jokingly say it's not summer until the Special Asset Summer School series starts. So welcome, Jameson. He's in our Greenville office. He is a creditors' rights attorney focused on advocating for financial institutions, lenders, and other creditors in collections and bankruptcy proceedings. He has completed a term as a judicial law clerk for the Honorable Joseph Callaway, with the United States Bankruptcy Court Judge for the Eastern District of North Carolina. He has now devoted his skills to helping clients navigate the complex issues related to commercial loan transactions, foreclosures, receiverships, liens, restructuring, and insolvency. Next up, we have Thomas Wolff. This is not his first Special Asset Summer School series. Thomas is joining us from our Raleigh office today, and his practice encompasses a wide range of creditors' rights law and business transactions. His creditors' rights experience includes representation of financial institutions, lenders, community associations, and other creditors in collection and bankruptcy proceedings, as well as navigating commercial loan transactions and workouts. Thomas routinely represents creditors in commercial litigation in addition to drafting complex loan and settlement documentation. I think y'all have heard just about enough from me now, so I am going to turn it over to you, Thomas.
Thanks, Haley. Welcome, everyone. Glad everybody was able to carve some time out of the middle of their day to spend some time with us and talk about bankruptcies, which is everybody's favorite lunchtime conversation topic. But really, no, again, my name is Thomas Wolff. I'm in our firm's Raleigh office. As Haley said, I handle a lot of bankruptcy, foreclosure, and state court litigation. Subchapter 5 and the bankruptcy chapters that we're going to talk about today is just one part of my practice here. The idea here is to give you a bit of an overview of the Subchapter 5 process. We're naturally going to touch on Chapter 11s and Chapter 13s a little bit to give some context about the pros and cons and the differences in these different chapters and kind of what to expect. Feel free, again, to ask questions as we go. If I'm diligent enough and notice the questions in there, I'll try to answer them as they pop up, but certainly, if there's any questions, we'll definitely get to them by the end, time permitting. But feel free to reach out. We'll try to keep this as much of an open conversation as we can for a webinar. But jumping right into it, Subchapter 5 is a newer process in the bankruptcy code. It's a subpart of Chapter 11, which has been around forever, but Subchapter 5 was carved out in 2019 when the legislature passed the Small Business Reorganization Act. It's very similar to Chapter 11, but the goal here is to create a process that is faster, cheaper, and more efficient than Chapter 11s, which tend to be large, slow-moving cases, especially when creditors and debtors can't agree. But again, the point is it creates a process that has accelerated deadlines to speed up that process and eliminate some more of the red tape and other administrative burdens that come along with Chapter 11s. Meant solely for debtors engaged in commercial business activities as well. This is not for just an individual debtor, consumer, and their home debts. This is for consumer commercial businesses only. Just like Chapter 11, it starts with a flurry of first day motions. Takes a lot of careful planning by the debtor on their part to make sure that they're able to file the bankruptcy, file some first day motions that allow them to use cash collateral, to employ professionals, to use bank accounts, pay employee wages. The idea is to make sure that it's a fluid process, that when they file the bankruptcy, they can continue to operate, meet their payroll deadlines, and make sure business isn't otherwise interrupted. Again, the whole idea of the bankruptcy and the Chapter 11 process is to keep the debtor on their feet, keep the process moving fluidly, and these first day motions are all meant to kind of get around the automatic stay issues and things that are in place once they file bankruptcy to make sure that there's no interruption, or at least if there is, it's very short and it doesn't negatively affect the business operations. So once that happens, secure creditors, best to get involved right away. It's a quick process. And if you raise your hand early and are involved in that process right out of the gate, you have a lot more control over the process. It's, at the end of the day, it's a large negotiation. Everybody wants to carve out their piece of the bankruptcy plan that's going to provide as much as they can. And so there's always a little bit of jockeying, but there's also, as any good negotiation has, there's a bit of leeway. And so once those first day motions are filed, secured creditors should get involved, try to protect their interests. If you need to make demands for monthly payments, adequate protection payments, if insurance needs to be placed on collateral, all those things are part of that negotiation to make sure that the business operates, but that secured creditor is not the one that's being forced to pay for the cost of the bankruptcy without having that adequate protection in place. Again, normal Chapter 11 confirmations tend to apply in this situation. There's some slight differences, and we'll touch on them a little bit more later when we go into the process a little more depth. But the biggest changes are there are no disclosure statements in a Subchapter 5 versus a Chapter 11. You still get the same information through a Subchapter 5 plan that you would get in the disclosure statement, which is just a list of information that helps the creditors make an intelligent decision based on what they're seeing on finances on paper, what the bankruptcy plan is, and how they propose to make that plan work, whether or not it's feasible. In order to vote on the plan, which they're entitled to do, that disclosure statement is usually necessary. Subchapter 5 does not have that, but a lot of the same requirements do get rolled into the plan itself. Again, just part of the way to make this a more efficient, quicker process. Another important difference is a trustee is going to be appointed to help administer the estate. They're there to facilitate confirmation, help get the parties on the same page to get a plan that works for everyone. The goal in these is always a consensual plan where everybody's happy. Everybody takes a bit of a haircut, but everybody's happy with their ultimate result at the end of the day. I really want to try to avoid a plan that's not consensual because there's a lot of negative effects to that really do add to the cost of the estate. And again, we'll get to that a little bit more later once we get into things. The The idea is this is an efficient and affordable process and is going to be an alternative to the larger bloated Chapter 11 process when a debtor is eligible. Since this was instituted in 2019, we have seen a large increase in Subchapter 5s. It's a very, very popular process. According to the American Bankruptcy Institute, over 25% of Chapter 11s that have been filed since 2020 have been Subchapter 5. So a quarter of all of the Chapter 11 filings are taking advantage of this situation. 2023, that number increased to 44%. So it's catching on. People are used to it. They like it. It's a cost-effective option, and there's no signs of it slowing down. Small businesses are confirming plans at a higher rate in a shorter amount of time than we're used to seeing. In the Subchapter 5 trustees have issued a report and indicated that there's a double the amount of confirmed plans in Subchapter 5 as opposed to regular Chapter 11 plans, and half as many dismissals as compared to Chapter 11. So it's a good process, and the numbers don't lie, it works. And it's certainly something that's here to stay. There is a caveat there. I don't know if anybody follows current events, and we can flip over to the next slide, Haley. And that has to do with eligibility requirements. Getting into Subchapter 5 is got its limitations. You have to make an election and meet these certain requirements to be able to stay in this certain category. Number one is we got to show that there's commercial or business activities that account for at least 50% of the debts. The other thing is the debt limit. That's what's changed recently. So when this originally came out, it was 2.7 million. I had to have a hard cap of 2.7 million to take advantage. The CARES Act came around during the COVID times and increased that limit to 7.5 million. It was a drastic increase, but it opened the doors to a whole lot of businesses that were struggling during the time to take advantage of the process and get on their feet and remain in business. Again, huge benefit. Unfortunately, that sunset just this past weekend on June 21st, that debt limit went away and it's now reverted to just over 3 million. I think the number now we're at is 3,024,000 and change. But give or take 3 million is where things stand. So I think we're going to see a large decrease in the amount of filings until Congress gets together and tries to bring it back, because again, the numbers don't lie. It is an effective process and people like it. Debtors like it because it's cheaper for their clients. Creditors like it because they can get through to a confirmed plan much faster with a whole lot less hassle and hearings than they're used to in a Chapter 11 process. People thought that this debt limit was going to get kicked down the road. People were pushing for an indefinite extension of time to take advantage of it, or at very least, we're hoping for at least another 2 years. That didn't happen. It was getting ready to pass in the Senate. I think Senator Rand Paul was blocking the legislation for budget reasons, and that just caused things to fall apart and die on the vine this past weekend. But I don't think we've seen the last of it. I think this is something that's going to pop up in the future. I think legislature is going to get together and try to get that rectified and increase that debt limit going forward, whether it be for another year or two or indefinite. We don't know, but we definitely think that there's going to be some kind of movement, just maybe not in an election year this year. So the first big issue is how do we calculate those debt limits? It's not as easy as you would think. It's not a standard $3 million. We got to look at, these are businesses, there's individuals, there's affiliates involved. It's a process. So they look at an aggregate of all of the debts, whether secured or unsecured, and they even look at the debts of the affiliates of the company that's filed the bankruptcy to take advantage of that limit. It does not include PPP loans, if those are around, or any damages caused by rejecting leases. It also doesn't include debts that are owed to affiliates. What we're talking about are just the debts of the various affiliates all together, which has to be looked at in a whole. So how does this work in reality? You have business A, who is a trucking business. They sell and lease trucks. They got about $2 million in debt for their inventory and leasing debts. Maybe they have another guarantee on a $1 million loan for the owner's principal residence. Altogether, we're looking at $3 million. So yes, this would account for subchapter 5. This would definitely include, because 50% of the debt arises from commercial business, because 2 million were in inventory parts and only 1 million was for the personal consumer debt. So this would qualify. Now let's change that hypo a bit and say business B wants to file, who's an affiliate of A. Maybe they have just another $1 million in loans. Well, when they get ready to file, the court's going to look at the first filing for business A and say, well, you may have just $1 million and that qualifies on its face, but not when we add in the debts of A, which was another $3 million. And so that's going to kick it out. And this is kind of more of a practical problem that a lot of debtors' attorneys are facing, because you have to look at who's filing first, because not everybody's going to get into subchapter 5. So there might be some strategic planning involved on how to file, when to file, and who files, because sometimes not all the affiliates can take advantage. And then practically it's a problem, because if all of the affiliates file and some are in chapter 11 and some in subchapter 5, well, now they're on different timelines, different schedules. Some of these plans might be pushed out much further down the road than the abridged subchapter 5 section. So again, there's some practical issues that happen. Sometimes you just got to deal with it. Most of the time, the parties don't really mind, but they got to deal with the bankruptcy administrators and other uninterested parties that might come in and say, well, that's not how the rule works. We got to fix it. You're not qualifying. So who are the parties involved? On our next slide, the trustees are going to be appointed in these. That's different than chapter 11. They get appointed in all these cases, but their involvement is a little bit limited. The idea is they're here to facilitate the development of a consensual plan. They act as that intermediary, kind of a mediator between the creditors and debtors, to try to find out what works for everybody and get on the same page to get the process done efficiently. The debtor remains in possession of their assets. The trustee doesn't take control, and the trustee doesn't do their normal investigation work that they would normally do in other bankruptcy cases. The bankruptcy administrators, they're there to facilitate the bankruptcy process. They're looking at the code to make sure everybody's playing by the rules. Secured creditors and unsecured creditors, their involvement is pretty similar to any other chapter 11 case. Secured creditors are going to want to jockey for better positioning, looking at arguments over the valuation of their collateral. But they're going to be integral to getting a consensual plan filed, because the voting process needs to be followed. And so secured creditors have a lot of control in the negotiation process there. Unsecured, as you probably would expect, they can have some effect on the plan, but as an unsecured debtor, that control is severely limited. Another distinction there are creditor committees, not required in subchapter 5 as opposed to chapter 11, but they can be brought into play if it's necessary, or if the court deems on its own volition that it should be included. So it's possible, but has not been the typical case. And you can move on to the next slide, Haley, and I'll turn things over to Jameson to talk a little bit more in detail about some of those similarities with chapter 11.
Yes, thank you very much, Thomas. And there were a couple points I wanted to make. You made some excellent points earlier, and I just wanted to address with the first day motions. I agree it's very important to act early and act often. I've seen as a practical aspect that oftentimes if a secured creditor or anyone with interest in cash collateral does not make their objection known, oftentimes after those first day motions, when cash collateral comes back up second, third, fourth time, usually on a monthly basis, the court will sometimes just assume nobody else has interest and have those consent orders that the parties that have already noted their objection, they'll just form consent if the case is going well. And so if you don't act early and often, then you really can lose your ability to kind of make your voice be known and protect your rights under the bankruptcy case. The other point I wanted to make was in many subchapter fives, Thomas talked about how they're often used in chapter as an alternative to a regular chapter 11 because of the efficiency, because of how less expensive they are. And I think the stats he pointed out was something like 25% early on, as much as 40-something% in 2023. It'll be interesting how long Congress kind of drags its feet in extending the limits again, if they do at all. That'll certainly have an impact on whether or not subchapter fives are filed. But I think the other point of that is Thomas noted that this was a fairly recent development in chapter 11. And so as people are learning the process more, which, a webinar like today addresses, as debtors attorneys, creditors attorneys are learning the process better, they're realizing it is a better process to follow, and it can end up being more effective in favor of everyone's interests. So those were just two quick points I wanted to make. And as Thomas said, I'm going to talk a little bit more about kind of the details, the similarities and differences in subchapter 5, chapter 11 cases. We'll start with kind of the administrative differences in subchapter 5. And you'll notice as I go through these, many of the differences are purposed in cutting the more burdensome and expensive parts of a regular chapter 11, which meets the efficiency goals and process for small businesses, allowing them to make it through the process. It's a difficult process going through bankruptcy because obviously the businesses are already not, or typically are not, in a good state. And so having a more efficient process is very favorable to them. As Thomas mentioned, in regular 11s, there's no trustee, typically there's no trustee. There's just going to be the debtor in possession who will keep control of the assets, run the case. Whereas in subchapter 5, there is kind of a new player that's introduced, which is the subchapter 5 trustee. It's not the same as would be appointed in a chapter 7 or in a chapter 13, where they kind of take over the estate. It's more of kind of a facilitator. They are a mediator. They kind of negotiate treatment between the secured creditors and the debtor, trying to facilitate a consensual plan. I think you'll see as this webinar continues that the debtor's main goal in subchapter 5, I think, is to find agreeable ground with the creditors so that a consensual plan can be met, which provides a lot of leverage for creditors in getting favorable treatment. So in subchapter 5, as I was mentioning, the trustees appointed day 1. They facilitate the plan. They will typically serve through plan confirmation or all the way to the completion of plan payments, just dependent on the terms of the bankruptcy code and whether or not the plan was consensual at confirmation, or if a creditor objected and the court had to cram down the plan. There's no deadline. One other difference, there's no deadline for filing a plan in a traditional case, although, usually it'll end up being around 6 months on average, more or less. But in subchapter 5, there's a pretty hard deadline. The court, based on the code, it's required that it's 90 days. And I think, it has to be circumstances outside of the debtor's control in order to have that extended any further. And so that can be a difficult burden to meet. The expectation, again, and is the common theme with subchapter 5, is to keep things moving, keep it going on a quick basis. There's no United States trustee fees in subchapter 5 cases. This again cuts down. These are the quarterly fees that debtors have to pay. This again cuts down on the expense requirements that would be there under a regular chapter 11 case. And as Thomas mentioned, there's no creditors committee in subchapter 5. Frankly, they're usually pretty rare in North Carolina. I don't think I've seen many yet, but they're extremely rare in subchapter 5. Almost will never come up. And just to explain, a creditors committee is essentially just a representative group of all the creditors' interests. And again, common theme, it cuts down on the expense of the case. There's no disclosure statement. I think Thomas talked about this a little bit as well. There's no disclosure statement required in a subchapter 5. The plan pretty much is meant to comprehensively address everything that is needed in order to make an informed decision and vote on the plan. It'll provide, a brief history, projected income, the classes and treatments of each of the creditors, and things of that nature. Furthermore, the reporting requirements are not quite as strict in subchapter 5. An example of this is a debtor must submit under subchapter 5 a balance sheet, cash flow statements, statement of operations, and federal tax returns at the outset. But in a regular chapter 11, there's much more monthly reporting that's not quite as strict in subchapter 5 cases. One example I have of this, and when I was a law clerk, I remember a lot of the businesses that would file bankruptcy, which usually are not experts in accounting and budgeting because after all they did find themselves in bankruptcy, unfortunately. So some of those financial reporting requirements can tend to be very helpful when they get in the bankruptcy case and can really get debtors back on track. And another part of that is I think the bankruptcy is intended to be a very transparent process. And so what is required to be provided, different financials, will really shed light on whether or not a debtor's able to be successful and whether or not creditors should be in support, and if the debtor can comply with the terms if they're able to confirm a plan. There's no requirement for an individual in subchapter 5. They have even less reporting requirements, which kind of makes sense. I think subchapter 5 is kind of purposed in finding a common ground between chapter 13 cases and regular chapter 11 cases. So both individuals and entities can file subchapter 5, but individuals are not required to provide current monthly incomes. But again, this is balanced, I think, with kind of the efficiency in subchapter 5, where you've got those monthly cash collateral orders where debtors are required to provide budgets that show, their projections for the upcoming month and whether or not cash collateral should be confirmed or ordered, as well as once they're a couple months into the case, you also get to see the budget to actual, where you can see their income and expenses and how things are actually flowing. So with having the less strict reporting requirements, there are other ways of finding out the financial transparencies of a debtor. Also required in subchapter 5 is a status conference. This must be held within 60 days of the filing of the case. Although as a practical matter, this typically happens much earlier unless the creditor is, opposing it. Oftentimes, I think with some of those first day motions, you'll have the first day motions, which will be on an interim basis, and then you'll come back to have them confirmed on a more permanent basis. And so typically, the debtor will be expected to kind of provide a status update of what's going on in the case. And so oftentimes I think the judge will take that opportunity if there's no opposition and kind of check the box of a status conference being held. And one other requirement on the code is that a report must be filed 14 days in advance of that status conference by the debtor, where they essentially just set out the ways that the plan is going to be consensual and is going to be confirmed, and what efforts they have taken to negotiate with creditors in trying to find a consensual agreement for that plan. And I think I mentioned this, but subchapter 5, the idea of it is really trying to find a debtor where they can have a consensual plan, because that's going to be more favorable treatment to them under the terms of the bankruptcy code. one example of this is they get a discharge far earlier in the case if they can get it confirmed consensually, whereas the discharge will be pushed down the road if it is a crammed down plan and not a consensually confirmed plan. Another difference to talk about between regular 11s and subchapter 5s is in regards to property of the estate. Property of the estate does not typically include post-petition assets or earnings in a subchapter 5, but in regular chapter 11s as well as in chapter 13 cases, property of the estate will include that both assets and earnings that's acquired from the filing date of the petition until the case is either closed or dismissed or converted. So that's a big difference to note. If crammed down, however, there's a caveat to that, of course, every rule has an exception. If crammed down confirmation occurs, then the property will include post-petition assets and earnings. So just another point for the debtor to try and get a consensual plan confirmed, as well as another point of leverage for creditors in finding favorable treatment and negotiating with a debtor to get a consensual confirmed plan. Let's see. Excuse me. Haley, you can go to the next slide. Continuing with some of these similarities, we talked a little bit about the disclosure statement. So sometimes it's case dependent. Courts can order those to be filed, but the regular rule is going to be that they're not required. And the idea of these is to make an informed decision on voting for a proposed plan, and whether or not, you know, there's favorable treatment for creditors. Moving on to the actual plan, which is where the meat of what is going to inform your vote is found. Only the debtor. So another difference between regular chapter 11s and subchapter 5s is what's called the exclusivity period. So in subchapter 5, the debtor has exclusivity throughout the pendency of the case. Only the debtor can file a plan. Whereas in regular 11s, I believe the exclusivity period is, I want to say either 90 or 180 days. And then after that period runs, any party in interest can file a plan. And that will allow, and then basically they'll all be voted on, and whichever received the most votes will be the plan. But in subchapter 5, it's a pretty hard deadline. The debtor has the exclusivity to file, but they must do so within 90 days of the petition date. And kind of the language I was searching for earlier is they can get an extension only for circumstances for which the debtor should not be justly held accountable. And the risks are serious. If the debtor does not file their plan, then, you know, they're subject to their case being dismissed and tossed out of the bankruptcy court, which would, you know, result in consequences to the debtor, lifting the stay, etc. Only the debtor, one other difference that the debtor has that exclusivity for is that only the debtor may request modification of a plan. Some of the contents of the plan typically are going to be a definition section. This is a very important part of the plan, even though it seems a little dull, because, you know, based on how the debtor's defining terms can create real differences in the treatment of the plan. One example is the effective date. So sometimes upon the effective date, certain things will be triggered, maybe discharge, whatever it is. So oftentimes the effective date will be defined as 14 days after the order of confirmation. But, you know, that's not a given. That's not a requirement under the code. You need to go to the definition section and, you know, see how they define effective date. And if it's different.
To bump in while we're still talking about the plan and sorry, everybody. So we had a question Vince asked about this process kind of while it's relevant. We're talking about like the early part He asked if there are any items in the bankruptcy chapters that are unique to DIP financing and getting priority liens to provide that. Or if there's any issues with getting bankruptcy trustees to understand the true sale. Really good question, Vince. So yes, DIP financing in subchapter 5 is very similar to chapter 11, if not the same. It's still governed by the same exact provisions. You know, if you're going to provide DIP financing, there's going to be protections. You're going to get those priority liens put in place, but it's also flexible. It's not always the case. Sometimes it's okay to give junior liens to encumbered assets. It depends on a case by case basis, really. I don't think there's a one size fits all for DIP financing issues on that. But at the end of the day, it's very similar to chapter 11. It doesn't really stray too far from that. And the other one about a true sale, when we're talking about getting this, getting our plan in place and protecting assets. Usually the trustees, I mean, they're intelligent, they're attorneys that deal with these issues. We all swim in the same UCC swimming pool. So they tend to have a good idea of what's a true sale versus, just a disguised sale, or just a true lease type situation. But it's always a negotiation. There's always two sides and there's always room for disagreement. But trustees tend to be able to sift through those answers pretty well. So we've not seen a lot of issues coming from the trustee. Usually it's the creditor and the debtor that might have a disagreement there. But again, really good questions. And Jameson, sorry to interrupt while we're talking about the plan. Thought we'd hit on that.
No, I appreciate it, Thomas. And kind of like you mentioned, you kind of get zoned in and I didn't even notice the question was asked. So yes, thank you for that, Vincent, and thanks for addressing it, Thomas. Anyone else that wants to chime in, please feel free to do so. We'll do our best to catch them. So jumping back into the contents of the plan, I think I left off with the definitions, just how dull but important those are. Also, what will be included, which would have been in the disclosure statement, but is going to be a brief history and business operations of the debtor. These are basically just to lay out, why we are where we are today. Why did this debtor find himself or herself or itself in bankruptcy? And then the plan's going to go on to address, how we're going to handle it moving forward. Another thing that'll be added is liquidation analysis. That basically says, we're in a better spot here than we would be in chapter 7. You're going to have the classes and claims as to each of the treatment of each class, whether or not they're impaired or not impaired, as well as the final important part, which is projections as to how the debtor is going to make the plan payments going forward. One other unique process in subchapter 5 is modification of mortgages on principal residences. This isn't always going to apply. It's basically treated, or it's applicable based on how the loan proceeds were used. So they must have not been used primarily in acquiring the property. They must have been used primarily for the small business of the debtor, which kind of gets back to the debt limit and having over 50% being commercial or business activities. Payment of administrative expenses under the plan. This is a little unique as well. Administrative expenses are typically going to be paid in chapter 11. They have to be regular chapter 11s. They have to be paid right at the plan confirmation. Whereas in subchapter 5, it's a little bit different because debtors are allowed the option to pay them over the life of the plan in those 3 to 5 year payments, which is very helpful because again, it just creates a process that smaller businesses can comply with and not get into default in their plan. And you can go to the next slide, Haley. So one thing I've hit on a couple times is how important the confirmation process is. Pretty much in bankruptcy in chapter 11, that is the hurdle the debtor is trying to meet, is getting a confirmed plan. That's really the biggest part of the case. And so there's a lot, we've hit on a number of them, but there are a lot of incentives for the debtors to have a consensually confirmed plan. Essentially, this means that or in confirming a plan, the requirements are almost the same under the consensual process as they would be in a regular Chapter 11, except for one, which is just regarding how disposable income is paid. In Subchapter 5 is 3 to 5 years. In regular 11, it can be extended further. Whereas cram down rules are a little bit different. One difference in Subchapter 5 is there's no absolute priority rule. This is essentially the idea of, it comes up most in equity holders and owners of the company, but this is the basic idea that a lower class equity holders are going to be at the bottom. A lower class cannot take under the plan unless higher classes have been paid in full. And so Subchapter 5 tosses that out. The idea there is basically to, again, make a more favorable process for these smaller businesses. Another little difference is in Chapter 11, you have to have to have a cram down, you have to have at least one creditor vote in favor. Subchapter 5 does not have that same requirement. It only requires that, or it doesn't require any creditors vote in acceptance. It just has to be, the court must just find it fair and equitable and no unfair discrimination. As far as payments under the plan go, it's typically going to be the debtor handling it if it's a confirmed consensual plan. However, if the plan is a cram down, then the Subchapter 5 trustee will stay in place throughout the plan and make those payments in carrying out the terms of the plan. If it's consensual, the trustee is discharged from the case at plan confirmation. As far as the timing and scope of discharge, if it's a consensual plan, discharge is going to occur early on. It's going to be right at confirmation. If it's crammed down and non-consensual confirmation, then discharge is going to be deferred to either the 3 to 5 years in which the debtor has for making payments. Let's see, one other difference is post-confirmation modification. The debtor is the only entity that may make modification if it's a consensual plan. And when modification is made, the requirements are that the circumstances warrant modification and that the modified plan meets applicable confirmation requirements. In other words, this basically says the debtor cannot have a plan confirmed only to later modify it in a manner that's inconsistent with bankruptcy law. And we can go to the next slide and I'll pass it back over to Thomas.
Yeah, thanks, Jameson. So we're going to have these slides available afterwards, I believe. So I know we're running a little bit low on time, and obviously there's a lot of information to digest here. So I'm going to start kind of moving through the next couple of slides pretty quickly. We're going to talk a little bit about the comparisons to Chapter 13, but I'll just hit some of the highlights there. But certainly you guys are free to check out the slides later and at your own leisure. So essentially, Chapter 13, it's also an alternative to that as well. The debt limits between these two chapters are a little bit different. Just like Subchapter 5, the limits changed with the CARES Act, and which is also sunset, so we're back to normal. Chapter 13 is a lot smaller. It's got a $2.75 million debt limit as opposed to the $3+ million for Subchapter 5. But what's sunset on that chapter is that there's now a two-part test that comes back into play where you can't have more than $465,000 in unsecured debt, and you can't have more than roughly $4 million in secured debt. Under the CARES Act, they changed it to just $2.75 million flat. Doesn't matter how much of each debt. But now that that act is sunset, we're back to having this two-part test, which again makes it a little bit more difficult for debtors to get into certain chapters and take advantage of those provisions. So Just like chapter 13, subchapter 5 allows for individuals to file. It's not just for businesses, but again, part of it is the commercial business income. You got to be operating the business. The majority of your business, your debts and liabilities need to come from the business. It's not meant for just the individual homeowner to take advantage of. The same goes with spouses. Two spouses can file in chapter 5, but the debt eligibility requirements are going to apply to both spouses just the same. One key difference, though, with chapter 13 is there's a co-debtor stay that comes into play. So for all of those co-debtors that are not necessarily filing bankruptcy but are on those debts, without a co-debtor stay, we can now pursue those with state court remedies, get judgments against those non-filing entities. So that's a beneficial part of subchapter 5 to creditors. That gives us a little bit more leeway to pursue assets rather than waiting through the bankruptcy process. You go on to the next slide. The plan process, I don't want to beat a dead horse. I know James did a good job talking about the differences in the plan process. Just like chapter 13, there is an opportunity to object, whereas chapter 13 is an objection and a hearing that's held. Subchapter 5 allows creditors to vote on the process. Makes it a little bit quicker, more efficient, and easier, although there are still hearings that have to be held and objections that have to be filed. It's still a little bit more onerous. Confirmation requirements, again, Jameson described a lot of those, but the idea is to get a consensual plan. The parties don't want a cram down plan because the trustee needs to stay involved. If it's consensual, the debtor themselves can make those payments directly. If it's a cram down, the trustee needs to stay involved and handle the payments, at least for some time. It depends on kind of what the parties agree to. But the idea, again, is to try to keep this consensual, to get rid of the trustee, to get rid of the reporting requirements, and move back with the business opportunity, the business part of things, and rather than the bankruptcy. Sorry, I lost my page here. Again, modification of secured claims is important as well. Each is a little bit different. Residential mortgages are handled differently depending on which you're in. Chapter 13 is going to hamstring those debtors and prevent them from making modifications, whereas subchapter 5 gives you a little bit more leeway. Purchase money security interest in subchapter 5 can be bifurcated and kind of use that to their advantage to try to move the classifications to pay unsecured versus secured, whereas chapter 13 requires debtors to pay it as a fully secured debt. And so there's a lot more leeway for debtors to utilize the process to create a consensual plan and take advantage of some of those things. So yeah, as I was saying, with the consensual plan, the trustee service terminates immediately with substantial consummation of the plan. And that's a bit of a flexible term. That means that the parties have at least moved forward with the plan. They transferred the property, they assumed the business, and they've started distributing payments. So that could be immediately, that could be a week, that could be a month. It depends on a case-by-case basis. But that happens. When that happens, the trustee is then let out of the process, and then the debtor can handle payments themselves. That's for, and when you have a cram down plan, again, that's a little bit different. The trustee has to stay on, make those planned payments, and that's going to lead to more expense that the debtor is going to have to foot during the process. So there's a lot of incentive to get around that, which is going to lead to a lot of the negotiations. And Jameson is going to talk about that in just a second, about those advantages and how to take advantage of that for creditors to get a beneficial treatment in a plan. And that's one of the ways to try to use it as a lever and twist the debtor's arm, is trying to get that consensual plan, because again, that's the real goal here. Again, the effectiveness of the plans is a little bit different. If you have a consensual plan, it's effective immediately. If it's a cram down, you're talking about 3 to 5 years. And the same with chapter 13, that's effective after it's completed, which could be 5 years later. And that's another one of the big issues that we can use to our advantage to try to get around when we're having those negotiations. I'm going to skip past the next slide, which is a little bit more information that compares the two. But, you know, post-confirmation issues in subchapter 5, only the debtor is allowed to modify the plan. They can't have a post-confirmation modification of a consensual plan once it's been substantially consummated. So again, once we hit that point, the terms are locked in, it's the new contractual obligation, and that's how the parties need to move forward. There's no way to change it, and there's no hardship discharge allowed in subchapter 5, so you don't need to worry about those unforeseen issues popping up beyond the control that's going to change the way payments are made. And again, I'm going to flip it back over to Jameson, who's going to talk a little bit more about the advantages of how to handle those negotiations with the little time we do have left here.
Yeah, thank you, Thomas. And I'll just say in the comparison of chapter 13 and subchapter 5, I think it's important to note, because as long as the debt limits are lower, that is going to be a consideration for individuals filing bankruptcy, whether they should go subchapter 5 or chapter 13. But yes, getting into some of the advantages of subchapter 5, I'm going to start with just kind of a summarization of kind of the things I've hit on earlier that are kind of the big standout portions of subchapter 5 that make it a good choice for debtors. So as I mentioned, there's no absolute priority rule. There's no requirement that there be an accepting class for cram down confirmation. The projected disposable income rules are different. The means test standards are not going to apply in subchapter 5. The subchapter 5 plan can modify certain residential mortgages in specific situations based on how loan proceeds are used. Post-petition assets and earnings are not typically going to be part of the estate. Immediate discharge is going to happen upon confirmation, and there will be no modification of a plan by trustee or creditors. And a lot of these advantages are, one, why the debtors are so inclined to file subchapter 5, but also are dependent on a consensual plan. And so that gets to our point kind of during this entire webinar of the leverage that creditors hold in negotiating plan treatment of their claims, because as is a common theme, and I've said it too many times already, but you know, the debtors want a consensual plan, so it's helpful for creditors to have these advantages in negotiating treatment. I'm going to move into some of the practical considerations under subchapter 5. One thing to be aware of when reviewing plans is whether or not the debtor reserves a right to object to your claim, which is often a standard provision in subchapter 5 plans. And so when you're going to vote for a plan, you want to make, and in addressing the treatment, you want to make sure that you haven't allowed a valid claim for the appropriate amount in advance of having that hearing on the confirmation of the plan. One other practical consideration is what happens at default if the debtor's not performing under their plan? How many chances are they going to get before the automatic stay is lifted and you can, proceed under your state law rights? Typically, this is going to be controlled by the terms of the plan, of course. Oftentimes, what I see in most plans is just going to be a typical notice period of the debtor basically saying, hey, you're in default, this needs to be cured. That you'll then give them whatever amount of days under the plan, probably 21, I see pretty often, but whatever cure period it is for the debtor to get in line with the terms of the plan. And then if not, you bring it before the court and notice the default, and then the plan may be dismissed or the court may take other action. But that's typically the process of what happens, because the loan documents are typically not going to be what controls. It's going to be the terms of the plan once a plan has been confirmed. Also, in line with plan negotiations, if a debtor confirms a plan by consent, meaning all vote in favor of it, no objections, then it will receive an early discharge at the time of confirmation. If not, the court has to approve the plan after a contested hearing, and there won't be a discharge until all plan payments are completed. This is 3 to 5 years. The bankruptcy code requires that the debtor's plan pay all projected disposable income under the plan to creditors for at least 3 years. And these payments will be made under a hierarchy. The priority and secured claims are going to be paid first, and then the general unsecured claims are going to be paid at the bottom last. Payments, typically, they can be in whatever the plan terms require, but they're typically going to come quarterly. And the estimated, and unfortunately, general and secured creditors are going to get the short end of the stick, oftentimes receiving cents on the dollar.
Yeah, that was, sorry, Jameson, that's really the hallmark of this whole process and highlights that importance and the leverage that creditors have here. Is not only do they eliminate the need for administrative expenses going forward, but getting a consensual plan eliminates the need for a costly hearing. Anybody who's been involved in a Chapter 11 hearing knows those can be drawn out. They can be multiple days. You have witnesses on the stand the whole time. It's an expensive process, but above all, that discharge comes immediately on confirmation when it's a consensual plan. And that's what the debtor wants. They want that clean slate. They want it right now, and they want to be done with the process and move on. If we can't get a consensual plan in place, then they're stuck in a bankruptcy process for 3 to 5 years. And so, again, it just hits home that part is that's where the real leverage lies. And sorry, Janice, I'll let you kind of keep going.
Absolutely, Thomas. That's an excellent point. And so kind of as a final point, I'm just going to hit on the options for opposing confirmation and, what using that leverage, what can that look like? One thing you can do is push for a longer plan. If the debtor's hoping to be done in 3 years, you can kind of try and push it up to more closer to 5 years, 60-month period. Another interesting, and this isn't going to be approved by all courts, but it gets to the projected disposable income and what debtors projecting under the plan. Sometimes this can be pessimistic. You may think, well, the debtor's going to perform better than that. We want to receive more under the plan. So you can request basically quarter or biannual true ups where you use the actual disposable income rather than the projected. That's a neat little trick to use sometimes. Both are, but that's going to be discretionary within the court. And you can try to negotiate it with debtor's counsel in exchange for consent of the plan. And one way to do this is just by disputing their projections in court. But again, this can be, as Thomas mentioned, kind of an expensive and drawn out process. You may have to hire an expert to review their finances, or potentially have somebody have an attorney depose the debtor to get to the bottom of why they're projecting that. And so, it can be drawn out. And that's most of what I've got for today. I'll turn it back over to Thomas.
Yeah, thanks, Jameson. Obviously, we're kind of butting up right against the time. So if we left you guys with any questions, you want to follow up afterwards, feel free to email Jameson, myself, or Haley, and she'll get us the questions. If you have any, happy to have kind of conversations after the fact and kind of follow up on anything else that's on here. Feel free to take a look at the slides once they get sent around, but we'll be here happy to continue the conversation if anybody would like to.
Yeah, thank you guys. Jameson and Thomas, if y'all wouldn't mind just doing me a favor, maybe dropping your emails into the chat feature, make sure it's going to everybody so that everyone can have your emails right there. But it'll also be on the slides that I send out. So feel free to answer questions tomorrow. We are coming up on time and we want to be respectful of everybody's super busy day. But I wanted to thank you all, and I want to thank Jameson and Thomas for a great kickoff to our series. For those of you in attendance following this webinar, you'll be sent an email with the recording of the session as well as the slides. That will probably come tomorrow or Friday for me. Please save the date for our next presentation on July 17th, and that's going to be with Lance Martin and Paul Fanning on Ponzi schemes. So it's really interesting. So thank you so much for your participation. And that is going to conclude today's webinar.
Thank you, Haley.
Yep. Thanks so much, everyone. Hope you have a
Thank you.
great day.